First, though, let's go live to our correspondent, David Spunt. He is live outside the U.S. Supreme Court. So this really ticked along. And I know we didn't hear much from, if any at all, from Clarence Thomas. So I'll be curious to see what you have to say about that, too. David, take it away.
Well, hey, Harris, we did hear a little from Justice Thomas, but not as much as we've heard in the past few years since he's been speaking up more during these cases. And whether these justices like it or not, they are now square in the center of the 2024 presidential campaign. No question about it. Sometimes you hear these cases and you can kind of get an inkling of how these justices are going to rule. It's a tough one here. This went on almost 3 hours. This is something the Supreme Court typically allots an hour, hour and a half. This went almost 3 hours to show you the stakes here. This case is about much more than Donald Trump. This goes into the future with presidential immunity. The former president, though, charged with attempting to overturn the results of the 2020 presidential election, claims that allegations surround a time when he was still president. He says that he cannot be indicted because he was president. His attorney, John Sauer, pressed on several points of this very argument. Here he is in an exchange with Justice Ketanji Brown Jackson.
I'm trying to understand what the disincentive is from turning the Oval Office into, the seat of criminal activity in this country.
I don't think there's any allegation of that in this case. And what George Washington said is, what Benjamin Franklin said is, we view the prosecution of a chief executive as something that everybody cried out against as unconstitutional. And what George Washington said is, we're worried about factional strife.
And you mentioned Clarence Thomas. Here he is questioning Michael Dreeben, the attorney representing special counsel Jack Smith.
Mr. Dreeben, does the president have immunity, or are you saying that there's no immunity, presidential immunity, even for official acts?
Yes, Justice Thomas, but I think that it's important to put in perspective the position that we are offering the court today. The president, as the head of the Article 2 branch, can assert, as applied, Article 2 objections to criminal laws that interfere with an exclusive power possessed by the president or that prevent the president from accomplishing his constitutionally assigned functions.
And the clock is ticking. End of June, we should hear something, although it could be sooner. Harris?
All right, and there are protesters everywhere these days. Great reporting. David, thank you very much. So, Kayleigh, you and I got into a detailed conversation when this idea of official acts of the former president versus private acts. Let's bring the audience into our conversation on that.
Yes, so this was huge, and this was a thrust of what we heard today. If I'm former President Trump and I watch this, I'm actually feeling quite good about what I learned about, let's say, Justices Kavanaugh, what I learned about Alito, what I learned about Thomas, and I would add to that list Gorsuch, and here's why. They both brought up Kavanaugh and Gorsuch, and it was unclear where they stood before this moment, but they both brought up the issue of remanding, meaning sending this back to the lower court for more proceedings. And in fact, have their quotes here. You had Kavanaugh who said there's some private acts, there's some official acts. That analysis should be undertaken by the district court. And John Sauer said, yes, of course. Then you go to Gorsuch, you left open the possibility of further proceedings. Yes, further proceedings. So that's 4 people who brought up potentially remanding it. Amy Coney Barrett, however, brought up the possibility of allowing litigation to play out with the official acts and allowing Jack Smith to continue forward on the private acts. All of this to say, why is this so important? The issue of remanding to a lower court. There was a case, it was called the Vance case, Vance v. Trump. It was about Cy Vance, ironically, trying to get documents for the Stormy Daniels case. And Trump said, no, I have absolute immunity. The court said, no, 7-2, you don't. But they remanded it to a lower court for further proceedings. That was July of 2020. The outcome didn't come until 8 months later, February of 2021. So if you get a remand, you potentially, with that precedent, could get an 8-month delay.
Yeah, and of course, Emily, a delay is a defeat for the political chase that this has been for Democrats.
So much, so much. There's 2 things that stuck out to me in addition to what Kayleigh just articulated, and I want to break it down for viewers. So number 1 is about intent. And a few of the justices, Gorsuch and Kavanaugh, they sort of went into, look, if you're, and Amy Coney Barrett to an extent, if you're operating under an official capacity, then at what point is intention separated from motive? And isn't one to assume that any candidate would be acting, of course, always with the intention of being reelected? And what they voiced the concern for, which is this is what is most important, is precedent. And they voiced a concern that they would establish precedents, essentially, quote, by Kavanaugh, the dangerousness of accusing your political opponent of having bad motives. And again, in this sort of circular argumentation, well, yes, my intent was to get reelected. Aren't we all as candidates here? And as Amy Coney Barrett pointed out, and if you are indeed operating within your official capacity with specific enumerated powers that have been authorized to you, then how are you to parse out sort of a bad motive? So I think look for that to be reflected in the decision. And the second thing is one of what petitioner, which is President Trump, is arguing, which is that all of these behaviors were official and therefore I am immune. What you heard just here, this was the DOJ counsel saying, we want you, court, to operate the Youngstown analysis. And what that means is instead of accepting what Trump said, look, I was president, I am immune, they are asking the court to apply in 1952, none of us were alive then, Truman.
Not even me, and I'm old.
Truman, he directed the Secretary of Commerce, this was during the Korean War, he directed the Secretary of Commerce to seize the steel industry. What happens? It goes to the Supreme Court. They articulated a framework to analyze whether indeed he had the power, whether indeed that president was authorized to do so. And it has to do whether you operate in concert with Congress, whether you operate in voids or sort of just on your own independent authority, or in direct contraindication of what Congress has authorized. Those two things stuck out to me, and they have great consequence here.
So, Kellyanne, at one point, Michael Dreeben, who is the attorney for special counsel Jack Smith, said, we are not endorsing a regime that we think would expose former president to criminal prosecution and bad faith, as Emily was just talking about. And he goes on to say, for political animus without adequate evidence, a politically driven prosecution like that would violate the Constitution under Waite versus the United States. And then Kelly Kubacher-Bond, who was on set, and you didn't see us earlier because we were in the hearing watching it, ready to pick it up. She said, you know, considering what we've seen unfold in New York and the fact that Michael Dreeben was part of the special counsel Robert Mueller's team, a failed politically driven investigation, that's kind of rich.
It's very rich. It's as if he's been preparing for this argument so much he hasn't been paying attention to what's happening right down the street here. Right. Look, I want to set the table this way. The provisions and the protections and the promises of the U.S. Constitution apply to all of us, thank God. That includes Donald Trump. I want to tell his haters and his critics and his naysayers who've been trying to get Trump for 10 years now that he may not be above the law, but he's not below the law either. And I heard that in some of these justices' arguments today, writ large. Justice Gorsuch, he said future use of criminal law to impugn the motives or intent, Emily, of political opponents, it's dangerous. And then he also said something we all need to remember. What is the Supreme Court's job? He said, we're making a law for the ages. It's not about Donald Trump. If I were Joe Biden, I'd be very worried today. Because are we to believe that the Biden family's acts, all the gazillions of dollars that they've shoveled in, were public acts? He had left the vice presidency. He was not running for president yet. So I think everybody needs to worry. Also, I was very struck by Justice Kavanaugh quoting previous opinions by Justice Scalia and basically saying that Justice Scalia said, the question is really what does the law permit, not what did the law produce in any specific case. Again, they're broadening this out. And if I were Donald Trump, I'd be very happy today with this, to the extent he can be, because I think there were three options. No, full immunity is probably a 10% chance of that, then there's no trial. No immunity, you're going to have a very quick trial. Since the only thing that I've seen ever go quickly in New York City and Washington, D.C., places where I've lived for a appreciable amount of times, is the Trump court calendar. The only thing ever moved quickly in Manhattan or D.C. is Trump's court calendar. So be an immediate trial. I don't see that happening. The remand is the best possible outcome for him because I think it will drag on and on. I'm not sure they're going to all buy this idea that you said Amy Coney Barrett put forward, the justice, who's great, but her, let's separate out the private. Even that would take a while.
And that would have to be decided at this level. Nobody was suggesting that one person suggested that you kick it down to the district court and let them decide it. But for the most part, you'd probably have what's official versus what's private decided here. That's still going to take some time, too. All of it involves a delay. The question is, does the delay go past the primary season being over? Does the delay go past the election being over?
I would say yes. And by the way, Donald Trump's not available because he's stuck over here, too. So there's that. Just one quick thing. I think Justice Alito blew up the Department of Justice's entire argument. He said two very important things. He basically said, won't this lead us into a cycle where new presidents go and prosecute their political opponents? And he said, we've seen how this happens in regimes all across the world, and it destabilizes the government, the country. The second thing he said was, quote, if the president gets advice from the attorney general that something is lawful, is that an absolute defense? This is important because Donald Trump was receiving information from people I have called out as charlatans, showmen, and supplicants in front of the Resolute desk, and following that information.
Yeah, that's very interesting, because who wouldn't take the advice of the top attorney in the United States? I just don't know who that individual would be. Real quickly, I want to go to Paul just to get your thoughts, and then we've got Shannon Bream who's available too.
Very difficult to ascertain a commonality here. It's going to be a very complicated decision when we get it, and it could be a while. I'd say within a month. All right, and let's see how that plays out for the election. I do think that remand is likely the most likely possibility here. It's going to turn on official act versus private act. I think that's very clear. That's one of the few commonalities that we can probably go to. And Gorsuch, I think, nailed that when he started talking about, well, how far are we going to take that? Are we going to go into motive? Because you can make an argument that it is the official duty of a sitting president to preserve the integrity of an election. What if, let's take an outlier, and you notice there's a lot of what ifs in this discussion here, right, from the justices, because they understand, as I believe Gorsuch said, that we're speaking for the ages, right? So let me give a what if. What if everything Donald Trump said was accurate? What if, in fact, he was preserving an election that ended up going against him? In other words, what if a sitting president was preserving the process in a way that actually would end up having him lose? Does he not have that ability, that requirement for the American people? So it comes down to whether or not preserving the integrity of an election is an official act. That goes into Donald Trump's mind, and that's why I think you're going to see a remand, and it could turn on intent, I think, as you said, Emily.
Hey everyone, I'm Emily Campagno. Catch me and my co-hosts Harris Faulkner and Kayleigh McEnany on Outnumbered every weekday at 12 p.m. Eastern, or set your DVR. Also, don't forget to subscribe to the Fox News YouTube page for daily highlights.